quite an interesting, if slightly complicated subject, which the committee enjoy getting their teeth into. I'm very grateful to you for your evidence, and perhaps I could start with a very general question, which is whether you think businesses will actually be able to manage the additional responsibilities which will fall upon them with the change, and whether they are being provided with enough or even adequate support, education, advice and guidance from HMRC, whose initiative this is. So who would like to start?
I can start if that's
Thank you.
Okay. So I've got some figures here from a webinar that HMRC have done for businesses to help them get prepared for these changes. And they asked some straw polls during this webinar, and the webinar took place last week. Of those that answered the straw polls, 50% of those on the webinar were not confident in making status determinations. 49% have so far not taken any steps whatsoever to prepare for these changes, and 41% do not know how many individuals they are currently engaging through an intermediary. So I think all of those figures altogether clearly demonstrates that businesses are not in any way, shape or form ready for this change.
And the date of that?
19th of February.
Ah, right.
So just last week.
So can I just quickly describe
Yeah.
today's Financial Times story, a headline of which Rishi Sunak promises to be fair over IR35 changes, and it quotes the Chancellor as saying that a review will bring in, and I quote, some tweaks and improvements to make sure the transition is as seamless as possible. Question would be, what tweaks and improvements would be necessary to address those percentages?
Well, it's clear that there hasn't been enough education, and I think the HMRC's education programme was probably put on hold partly due to the election, which is something that none of us can control. But the fact is there is just not enough knowledge out there, and people are just not prepared from a business perspective. And those businesses that are prepared are spending a lot of money to get ready and get specialist advisors in, because don't forget this is very specialist tax law, which even advisors don't always agree on the outcome of.
Mr. Nye, welcome to the committee. I just asked a general question as to whether businesses were equipped to deal with this and whether they were getting enough support from HMRC. Does anyone have anything they want to add? There's no need to repeat the same point, but
So I think from the CBI's perspective, I think business readiness varies quite significantly across businesses. I think large businesses are probably more prepared, or as prepared as they can be, in the absence of final legislation compared to smaller businesses. But I think generally the delay in publishing updated guidance, which was only published at the beginning of February, and with final legislation still outstanding, is a significant issue. Generally, we would say reform sort of this significance, businesses would ideally like to see final legislation a year in advance, but potentially they're not going to see it until 17 working days before the reform is.
We've had some evidence that big businesses are prepared in advance simply by just saying to all the subcontractors, you're employed or you're no longer associated with this. Do you agree with that?
I think for businesses, certainty and simplicity are really key. And I think this reform, especially given that we haven't got final legislation, has not provided that certainty and simplicity. So I can see why some businesses are perhaps having to take that approach.
So was that a yes?
Well, I think I can't comment on individual businesses. I think it very much varies.
I'm not asking you to comment on individual businesses. I'm asking what collectively big businesses are doing. And as the CBI...
I think it's really mixed, actually. I think each businesses are looking at their contractor populations and the risk. So I think some businesses, and it has been reported in the press, are taking a position where they won't necessarily engage with as many contractors as they were previously.
So does the CBI not know what percentage of their members are actually reacting to this in that way?
I don't have a percentage.
Could perhaps you write to us or try and provide that information?
I've got a little bit of information to help on this point, if that's okay. There was a survey done this weekend by a large recruitment firm, S3, and they surveyed 1,500 contractors. 45% of those that responded to the survey said that their clients have not been using reasonable care in determining whether they are inside or outside IR35. Also, 18% said that their clients have banned personal service companies. So that's a percentage for you just from that survey this weekend.
Right, I know other colleagues want to come in. Mr. Chamberlain, do you want to comment on just the general point?
Just on this general point, yes, we understand that particularly in the banking sector, many sort of household name banks have taken the view that they will not engage with contractors anymore. It's pretty clear, although they don't always say it explicitly, that that's because of these rules coming in. And it's also likely that because they don't have the simplicity and the certainty, because we don't have the final legislation, that's fed into that sort of approach, that they've decided to take that approach. We surveyed our members, and 2 in 5, or 39%, said that their clients, our members are the contractors, by the way, the freelancers, the people who are likely to have their tax position changed by these decisions. They said that their clients indicated they're not planning to assess the individual freelancer engagements, but will either make a blanket determination, everyone's inside of R35, or they will just stop engaging with contractors altogether.
Okay.
Yeah, so just to support that, anecdotally we've heard from members that, you know, the firms
Can you speak up?
The firms that they were originally contracted with or engaged with have taken the sort of completely risk-off approach of saying that will no longer be the case. You can either be on payroll or lose your engagement.
Okay, Baroness Kramer.
You covered the question I was going to raise.
Right.
Well, we'll ask one little question. You talked about the adequacy, or the issue was raised of the adequacy of sort of education and information available. Even if you were able to sit down and work your way through the webinars, the information, to what extent would you then be in a position of certainty as a company to make the decision? Or does the instruction itself lead a very wide area, grey area, where there appears to be discretion, judgment and subjectivity involved?
Yeah, so I mean, this is a very complex area of tax law, and it's predominantly based on case law rather than legislation, which adds to its complexity. We would recognise that HMRC have taken significant steps in improving the check employment status for tax tool, which obviously has been of assistance, and the updated release in November 2019 is welcome. There still are areas of uncertainty in that, so it's not always the case that that tool can give you an answer. And so we'd welcome further guidance in that area. We'd also welcome further guidance on some of the specific questions that have to be asked or answered within the tool, because there are some, for example, financial risk is a good example, where you may take a different view on what constitutes financial risk, so having some guidance around how to answer that question would be very, very helpful. But I don't think you could say with absolute certainty in every case what the answer is. Obviously, cases do vary between complexity across the board, and some are more clear-cut than others.
I would probably go. Yeah, I would agree with that, and go slightly further and say that the difficulty is that the case law is disputed. So what one person's interpretation of, say, mutuality or obligation is, I know we don't want to get into we'd be here forever if we started talking about that.
We do. I asked the question before we started, what mutuality obligation, how it was defined, and everyone looked at their shoes.
Well, it's somewhat disputed. So HMRC take one view, and then the other courts have given a different view to that. So it is very difficult, in answer to your question, Baroness Kramer, for a client to say with certainty whether IR35 should apply in any particular engagement. And there's always the risk that HMRC could come along at a future date and disagree with them and say, no, we think you've got this wrong, and then be left with a huge tax liability. So for these reasons, you can see why clients would be very nervous about applying these rules, and perhaps tempted to say, let's just not engage any contractors at all anymore.
So the risk and benefit are completely asymmetric then. The risk is very high and the benefit is quite limited.
Lord Desai and then Lord Bridges.
Yeah, I'm very puzzled by this, because there was something in existence which was complex but understood by enough people to indulge in behavior which a lot of us think was unfair to the taxpayer. They were finding ways of avoiding paying a certain tax which people outside their remit were paying. So the businesses understood what it was that they were doing. And the HMRC is proposing a correction to that behavior. And suddenly everybody says, we don't understand the law. They understood it before perfectly well. And there's been a lot of manipulation. I mean, I as an ordinary citizen read about it and I get very angry that it is unfair to people who do a regular job for pay. And then suddenly I become self-employed and have fun. Now, everybody understands what's going on. It's only when we try to correct it that somebody says, oh my God, it is so difficult, we can't understand. I don't understand this. Well, either people knew what they were doing and were manipulating it and it's being corrected, or they didn't understand it.
Okay.
Sadly, they don't understand it when the tax is being corrected.
I actually think one of the main problems is not in relation to freelancers or contractors and the tax that they're paying, because don't forget their income is taxed from a corporate basis, so they're paying dividends tax when they draw money out of the company. They're also paying corporation tax at the end of the year and VAT. But the major problem is actually employers' national insurance costs, and that is what is not being paid when a business engages a freelancer through their own limited company. So it's not anything about tax avoidance from that individual. And actually, there was a survey done by the Department of Business in 2016, and they looked at the nature of self-employment. The project is called Understanding Self-Employment, and actually less than 1% of the people that answered that, of self-employed people that answered that piece of research, cited tax benefits as a reason for working for themselves. So I would dispel that theory, definitely.
So for Lord Desai's benefit, what is happening here is large employers using contractors, they then don't have to pay the employer's national insurance, and so they avoid that. Faced with these new changes, they try and recover the cost by putting that liability onto the subcontractor by cutting the amount of the contract, or alternatively by just saying we're not going to continue with this arrangement. Does that summarise it?
Yes, it does, and I wouldn't want you to think that businesses are avoiding tax by employers' national insurance by engaging freelancers. It's just not a tax that they have to pay by going that route, and so they often want skills on tap for particular projects, and then those skills come in on a short-term basis.
Yeah, you avoided the trap. Lord Bridges.
Just a quick question on mutuality of obligation and CEST. Mr Chamberlain, in your very good written evidence, you say that the lack of any questions on mutuality of obligation in CEST is a fatal flaw. So I take it, therefore, that you think that unless that is addressed by the Chancellor when he talks about tweaks and improvements, CEST is fundamentally flawed. And I wonder if others could just comment on that specific point on mutuality of obligation in CEST as well. Mr Chamberlain.
I mean, that's absolutely right. So HMRC take a view that mutuality of obligation is always present inside any contract. If there's a contract in place, there's mutual obligations on the parties. But there's another view, or there's a range of views, some of which have been mooted by judges in the courts, which say no, that it has to extend beyond that, and that the obligations must extend beyond that to establish that this is something that points to a relationship being one of employment. And because CEST doesn't test for it, therefore it can never give a accurate picture of what the true status is of the engagement which is under question.
Okay, Lord Tyree.
Can I just begin with one general point that touches on a point that Lord Desai made earlier? Would the panel agree? Why don't I start with Ms. Agopian, if that's correctly pronounced. Sounds Armenian to me with IAN at the end there. That old rules, old tax rules are generally well understood, and new rules often by definition are not. Mm-hmm. And therefore it's understandable that a new approach is likely to be less well understood and therefore less fully obeyed initially.
So I mean, I guess we should remember that these aren't necessarily new rules. These are just a reform to where the liability sits. So previously the tax liability, if the decision was incorrect, sat with the personal services company, and now it's sat with businesses. I wouldn't say that IR35 is necessarily a well understood area of tax law, and I think that draws back to the point that a lot of the decisions are based on case law, and case law evolves over time. HMRC have taken a number of cases to courts, and often the tribunals have...
And it's the case law that provides the certainty over time.
Yeah, and the case law develops over time, and so I think that is where a lot of the difficulties lies here.
Okay. Can I take you on to the cost?
Yeah.
Of the proposed change to the working of the rules, or describe it however you want. The government's estimate is 14 million.
Mm-hmm.
Have the CBI done an estimate of their members in order to establish their view of the cost?
Yeah, so I don't have a full implementation cost across the whole economy to give you. What I can say is that back when we initially responded to the reform and the consultation in 2018, we raised the point that many businesses were indicating that the system costs and the changes required to those alone could cost in the region of hundreds of thousands of pounds.
Per company?
Per company. From speaking to businesses in the last few weeks, as we've started to progress and businesses have actually started to incur those costs, that still does seem in the range, in the right ballpark. Businesses have given indicative figures ranging between £100,000 to upwards of £700,000. And a lot of those do sit at the higher end of the range. Obviously, that is large businesses that have provided those costs with thousands of contractors probably on payroll. But if you take that 14.4 million and split it across, I think, 60,000 engagers and 20,000 recruitment agents that HMRC expect to be impacted, that works out at £180 per entity affected. And I struggle to see how, with such a complex area of tax law, anybody, even with one or two contractors, could implement this for £180. And if you just look at those large business costs, that 14.4 million will be wiped out very quickly.
That's a helpful reply, a clear reply. It takes us to the point that we appear to be getting evidence that 14 million is an underestimate. Mm-hmm. What we now need to move towards is an estimate that's more realistic, based on evidence that could come from your members. Would you be prepared to try and put in place a survey? While you're thinking about that question, did you get a chance to read the letter from the ICAEW?
I mean, briefly.
To glance at
yeah,
it.
I
apologise. You only saw it a few moments after I did. This has taken a look at 6 firms and come to large firms and come to the conclusion on the basis of evidence from them that the cost is 3 million, which is that is 3 million just for those 6 firms, leaving 59,994 engagers so far unsurveyed.
Yeah.
I think on behalf of the committee can say we'd be very grateful if you could make that estimate. The next issue seems to be to find out what the counterparty cost to your members might be. What view do others on the panel have of the likely cost?
Well, it varies. I saw someone's social media post earlier today, and they were indicating that if they were previously on £600 a day, it would cost them, they would have to increase their rates now to £1,000 a day just to continue to take home the money that they currently take home. Now, that's particular circumstances, and it does vary widely. I don't know if you've got more information.
Would you be able to do a survey for us of what
Definitely.
your members think the cost might be? Mr. Chamberlain.
As this policy is all about moving the responsibility for determining IR35 away from the contractor, who are our members, towards other parties in the supply chain, it seems likely that there may be a saving there actually for our members, because previously they may have had to do things like have their contract reviewed to ensure that it was compliant with IR35, indeed have tax investigation insurance if they were unlucky enough to be picked on by for an investigation, which they may be able to make savings by not having those things. Not initially, because they're still liable for the previous 6 years, but as that sort of time period diminishes, there may be
long-term saving.
Yeah. However, the cost for them will come in what we fear is going to be the case, which is too many of them will be put incorrectly into IR35 because of the issues we've discussed around uncertainty and clients not wishing to, or being unwilling, somewhat understandably, to take the risk on saying IR35 does not apply to this engagement. And so people will be put into a tax bracket which is not the appropriate one for them, in which they may well find that the employer's NI costs, lawful life, are going to be pushed down onto them and find that they're paying considerably more in tax than they perhaps should be.
It might be helpful if we could also nonetheless see the likely straight line effect, the saving that you would anticipate were there to be no behavioural effects.
I think that's quite an important point, because the figure that's quoted by the revenue is a net figure, isn't it? It's not a gross figure. I mean, it's...
And so we'd be grateful for that. Any estimate of the behavioural effects of change, we're interested in that too, yes. But it'll be a difficult calculation based on a number of, no doubt, tendentious assumptions. By all means, let's have a look at that as well.
Sure.
I'm not sure that's a net figure, Mr. Chairman. That's the 14.4 million in costs. I'm not sure it's a net, because it says it's a one-off cost.
Yeah, but I think it was...
Savings
Baroness Kramer, you're usually right, but I think I read somewhere that estimate from the revenue was based on that there would be savings for some contractors, and that had to be offset against the costs for business. But does anyone on the panel?
I actually don't know.
Right.
Yeah, I do have it in front of me. So the net cost is the annual cost, which is the 5.3 million that they net off. The 14.4 million isn't a netted figure.
Is not?
Is not, no.
Well,
that's
there you are, Baroness Kramer, you're quite right. So what is the net cost then?
For the implementation costs, it's the 14.4 million with no netting off, and then for the annual cost, it's negligible.
No. Is the 14.3 million, is that the cost, the total cost to business after taking account of the savings that will arise or not?
So the 14.4 million is the total cost to business for implementation of the reform. So, for example,
so that's already taken off the savings, is it?
No, that's the one-off cost for setting up systems, and then HMRC have done another cost on an annual basis of how much it will cost business to administrate the reform, and that is netted off against the saving to contractors.
And that number is?
That is a cost of 5.3 million, and then they've netted off the 5.3 million.
So is that the number that's consistent with Lord Tyree's, the 3 million in the letter that Lord Tyree has referred to?
The 3 million comes out of the 14.4 million, I think.
Well, the implication must be, it's of the same type.
Yeah.
It is of the same character, but the implication of the letter must be that 14.4 is a considerable underestimate of the total cost.
Yeah. So just to clarify, HMRC have provided two costs, so one being the one-off system set up, and sort of what we're incurring now, and then the other being the annual running costs.
I think there's an opportunity for the CBI to give us clarity here as well as accuracy. They very rarely travel together, but I think in this area we do need it. Mr. Nye, you haven't been allowed to say a word for some time.
So just two real quick things. One, the cost that we've focused on for our members is the lost contracts, essentially. We're mainly concerned about contractors in our membership that have multiple contracts, and where they're being sort of forced into a more employment type relationship, and they ultimately have to make a choice. There's a couple of anecdotal examples on that. There was a point about complexity earlier, And I think we sort of touched around it, but we're really finding that the complexity is driven by the test itself. I mean, the fact that employment status is complicated is why people are having difficulty navigating it when they haven't really had to ask these questions beforehand. It's getting clarity on things that aren't well defined in law currently, like what is control precisely, and whether or not two people doing the same test in the same circumstances have a different interpretation of what control means. I feel like I'm the only person at FSB who's knows this inside out. There's very few people in HR departments at large banks who would have any idea. So that's what the sort of real bridge to the real space to get over is. It's those questions that people don't really normally ask, because it's either employed or self-employed, and this isn't a very good...
And that is what's going to create the uncertainty.
Exactly.
To which I was referring earlier.
Exactly.
I understood that point. I think just to finish, it would be very helpful if Ms. Kermode and Ms. Agopian could think carefully about what you present to us on the cost, because I think it might become an important aspect of this whole debate, both the annual and the one-off cost, the gross and the net, so that we can clearly see what the revenue are estimating the cost to be and what the cost to businesses and those affected is likely to be.
Okay, Lord Monks.
Yes, just in terms of the positions of some of the representative bodies that you represent, there's been an argument for another year's delay. The CBI, Federation of Small Businesses, have been pressing that, and others as well. Would you be worried about the reaction as a representative body from those members who are compliant, who are ready for it, who have spent some of this money, and so on? Would that be a problem?
Yeah, so I think 6 months ago we were very clear that across our membership base, most members would welcome a delay. I think we're now in an unfortunate position where having a delay or not, neither is going to be an ideal position to be in, and there's pros and cons of both. We'll have many members that would still very much welcome a delay, and for good reason, given the lack of final legislation and the guidance just being published, as well as a number of other areas that need to be worked out before the reform comes in. But as you've alluded to, there are many members that have spent significant amounts of money already on this, and they've had to make decisions as well on what they do with contractors, and that's sometimes been quite a difficult decision. So for those members, a delay now might not actually achieve the benefit that it would have achieved months ago.
Okay. And basically, if you stick to that position, would the members of the organisation be reasonably content with the scheme as it is, even if some of them would like a lot more time to adjust their systems to it, but nonetheless, are they reconciled to the fact that they're going to have to do it, as rather confirmed by the Chancellor in the Financial Times today?
So I think businesses very much support and understand the rationale behind the IR35 reform, and it is right that the government's looking at non-compliance in this area. However, the CBI have always been of the position that actually we would call for a more holistic approach, looking at the outcomes of the Matthew Taylor review, and also having unambiguous rules around determining employment tax status, which we've touched on before, and that those points should have been addressed before we looked at reform in the private sector.
So that sounds as if you're saying it should be abandoned until that's been done.
Well, I mean, I think it comes back to we would have much preferred to have seen a much more holistic review up front ahead of this reform, rather than just going ahead with this reform.
I think if a tax cut was given, business would respond very quickly and there'd be no costs. They're always not prepared for a tax increase.
Sorry, Ms.
Yes, thank you. So in terms of a delay, my organisation would support a delay providing there is something that is done in the meantime before these changes coming out. So you need to deal with, or rather HMRC needs to deal with the tax avoidance schemes that we're seeing out there at the moment. There are lots of offshore schemes that are targeting contractors aggressively at the moment, promising them increased income that is actually impossible to achieve within UK tax law. HMRC is very well aware of these, and they say they are taking action, but it is just not enough. And we need action to be taken to prevent contractors being sucked into these schemes. And they will get large tax bills. It's not too different to the loan charge fiasco that we've just kind of experienced. So I would plea for there to be proper enforcement action on those avoidance schemes.
Yeah, and we would say absolutely that it should be delayed. For all sorts of reasons. I mean, we would actually advocate for abandoning the policy altogether, but from where we are right now, a delay would be a very welcome step forward. Not least because we haven't got proper answers to issues around employment status that were indeed raised in the Matthew Taylor review. There is the problem of umbrella non-compliance. Many umbrellas, I should say, are entirely compliant, but they're competing against ones that aren't, and they are pushing people into what's called disguised remuneration schemes. This is how we ended up with the loan charge, partly. R35 initially came out in the year 2000 and pushed people, who should have known better, probably many of them, but it did push people into these sort of arrangements. Then you have this issue. And then there's just the problem of, notwithstanding the Chancellor's speech over the weekend, which was reported in the FT this morning, what the Chancellor's really saying there is he's acknowledging that this is going to be really complicated and difficult for businesses to comply with, which is why he's beginning to suggest things like, we won't be too heavy-handed. But businesses really need certainty. So what he should say is, this is a bit messy. We haven't properly thought it through yet. There's a review which is still outstanding. We're waiting for that to report. There's going to be further tweaks, we're told by the Chancellor in the FT today. So how long will businesses have to cope with these new rules? Well, not very long at all. And the other big advantage, sorry to take up all the time, is if there was a 12-month delay, it would give us a chance to look at the policy again, because like I think everyone else here, we completely agree that everyone should pay the right amount of tax. We are not here to advocate for tax avoidance or people sort of getting around the rules which are in place. But we believe that there are better ways to do it than this. This policy is going to do more harm than good. That is our opinion.
Monks, are you done?
Only on that very last point, just what's the better way?
Well, IPSE developed something called a Freelancer limited company with EY a few years back. It was designed specifically to target this problem of R35, and the idea would be that you'd have a limited company like any other, but it would have it would be tailored to freelancers, and it would be transparent. So people would say they're a freelancer. Once you've created that and people are inside that bracket, you can then come up with tax rules which everyone is broadly happy with. The problem that we have right now is that what the rules currently are saying is, if you fit this type of arrangement and the vagaries of mutuality or obligation apply or don't comply, then it's perfectly fine for you to pay tax in this way. But if we change that a little bit in ways that no one really understands, then you must pay tax in this way. It would be better to say people who are contracting are valuable to our economy, but we may need to adjust how they're paying tax because we might not have got that quite right. So let's identify who they are and apply a more transparent and fair tax regime to it.
Okay, Lord Roberto.
Well, I'm fascinated with this because really at the core of it all is that it is, I think, too hurried, is what you're all saying in another way, and that the detail has not been properly evaluated and not been discussed. Well, what is preventing HMRC, God forbid, preventing them from actually delaying?
Very good question.
Is it potential revenue loss?
I think that's my opinion. I think it's the revenue side of things. And just on that, if I may, HMRC has stated that the public sector reforms were successful and delivered an increase in compliance by virtue of the fact that there were more payroll taxes taken. Now, I argue that does not demonstrate an increase in compliance. It just demonstrates an increase in people being put on payroll, perhaps incorrectly. So I dispute that particular figure. But yeah, why don't they delay? Probably the revenue side of things.
Really?
Yeah.
Are we in that need? for a few months?
Well, when you look at the cost to business and the cost to individuals,
That's what I'm saying. No, we being, not the individuals, the government. Are we in that need? Well, I find it very ill thought through, I must say. And there was something else, if I can move on just for a second. Going back to the contractors for a moment, can I have your comments on whether the new rules will allow contractors to challenge a client's determination of their status?
So there are provisions in the legislation, which is an amendment to the previous Chapter 10, which came out, the public sector rules that came out in 2017, where you couldn't challenge at all. So if the end client determined IR35 applied, the contractor didn't even know who had made the decision. So they've changed the rules to address that, but we're very concerned that what's called the client-led dispute resolution service will do very little actually to amend an incorrect decision. I think it's unlikely that a big client is going to, once they've made the decision, is going to overturn it simply because the contractor says, look, I think you've got this wrong, and have you considered X, Y and Z? I think they'll just say, yes, we have considered it, and we still think that IR35 applies. What's really needed is access to some sort of independent arbitration service, or indeed the courts. But of course that would be so resource intensive. I mean, there's a practical problem with implementing something like that, because you'd end up with thousands of little IR35 inquiries, and as we know, they go on for years. So yes, it's difficult, but I do think that the client-led dispute resolution service will not be particularly helpful in addressing the core concern that someone may have got a status determination wrong.
I'd just add to that I think the contractor might even be disincentivised on even raising the issue. If it's a client that they value, a contract that they're desperate for, they'll probably just put up with it.
Yeah. It's David versus Goliath, like the slingshot. Sorry.
Can I just one quick one? Well, if your answers are very interesting. So next then, do you think HMRC is doing enough to notify people of what the requirements are, how they are to fulfill those requirements? Are they actually doing enough, in your opinion? No.
No. Yeah.
No.
Any advance on no?
I mean, I think, as I pointed out, the refinement of the CEST tool and the delay that the year delay in the use of that to refine the CEST tool has been very welcome. So has some of the things in the guidance that was published at the beginning of February, but I think there's still many more things that need to be dealt with.
Can I just ask you a very quick question? Yep. If you're advising the Chancellor and he is saying, I want to create a Britain fit to compete in the digital economy, in the gig economy outside the EU, would you say, Chancellor, you must proceed with this policy?
For those purposes, no.
Absolutely not.
Absolutely not.
no, definitely not.
So what would you tell him to do?
Resign.
Well, as I was saying, in fact, there's been a couple of consultations.
Yeah, you mentioned your scheme you did with.
Yeah, I mean,
I think the committee would like to see that. Actually, it was rejected as part of the consultation.
Yeah, that's right.
For what reason?
Yeah, well, they just said it was out of scope, and they also said some other. They said there was 3 other ideas that were out of scope as well, which weren't our ideas, but I think each of them would actually merit greater consideration than the policy that we have now. One of them was, for example, to introduce something like an engager's tax. We're all in agreement, I think, that the employer's NI is what we're really talking about here, which is missing when it's a self-employed or a contractor arrangement. So one thing you could do is you could put an obligation on a hiring organisation to pay something like an engager's tax when they engage a contractor, which would be a bit like employers' NI. Once you've sort of created it, chancellors can adjust the rate here and there, but that would be very transparent and obvious. It would probably push the contractors' rates down a bit as well, but that would balance out over time. And there wouldn't be any of this, this mutuality, all these difficult tests. It's just simply that's. So now that's not IPSE policy, but that's an idea which is out there, which is attractively simple, I think.
Whose idea was that?
I'm not sure. I know that Demos, the think tank, came up with a similar idea in a report.
Perhaps you could write to the committee.
Yes, I can send that, yeah.
Thank you. Baroness Kramer.
Just a lightning question. You're talking now about what kind of remedies that might work significantly better. In your view, should employment rights and tax on employment be linked issues that work together as a whole?
Yes.
Yes.
My view is that would be the desirable thing. Right now you have a situation where a client is going to say to a contractor, look, we've satisfied that this relationship is actually a bit like an employment. We want to control the work you do. We won't let you send a substitute, all the rest of it. However, we're not going to employ you. We're just going to ensure that you're put onto a payroll somewhere, and therefore we satisfy. Now, I think if the end client is saying what we want here is an employee, then they should employ someone. And if they don't want that, there should be a contractor. And the rights and the tax should all go in one thing. The aforementioned Matthew Taylor review talked about aligning employment rights and tax. And the government are committed to look into that in their good work plan. But we haven't heard very much more about that. And I do think that that's the kind of thing that they should be doing ahead of this.
So I see that the Chancellor at the weekend was saying that he thinks this approach that the government's suggesting is fair, but what you're saying is it's actually going to create a new unfairness in terms of employment rights, just to be clear.
Yes.
So the fairness argument is not really one that can play both ways.
Correct. I don't think it is fair.
And what it does for kind of lower paid people is it puts them in a very vulnerable position. If they don't, if they're being taxed as an employee and they're getting no rights whatsoever, and it's something that we've been talking about within the UK labour market for a long time, about everyone having minimum rights, etc. And this just is a massive step back, and it is fundamentally unfair for that reason.
Can I, at a previous evidence, it turns out that this bulk is either very low paid people or very high paid people. The low paid people definitely suffer from this unfairness in the contract, but the high paid people are getting away with murder. Sorry, I'm kind of using that. Now,
don't think we've had any evidence for that, Lorence.
HMRC says that if they implement this, they'll collect about £3 billion. So somewhere £3 billion is being lost to the country. And who's getting it? Has anybody done an analysis of that? Who is getting this £3 billion that the HMRC is not getting? Somebody must be getting it.
Well, what HMRC is saying is that individual taxpayers are getting the benefit of that because they should be paying the tax. And indeed, perhaps the hiring organisations that would be paying employers, NI, etc. So, but those figures are, I'm not so sure that I have seen a particularly well-argued justification for where some of those figures come from.
You don't think you'll make £3 billion?
Well, I think it may well make money, but the claim is at the moment that the revenue is losing that money. And in order to make that case, you have to make an assumption on the number of non-compliant IR35 engagements which currently exist out there. And because IR35 is so difficult to know in any one engagement, and indeed if you look at HMRC's recent record at the tribunal, they have lost many more cases than they have won. So HMRC's view of what is caught by IR35 is not always actually caught by IR35. So you therefore have to question the premise upon which they have based a calculation such as that. It may well be that there is not so many IR35 court engagements out there in the world as HMRC believe that there is.
But is it not possible, just picking up Lord Desai's point, that you get this extra money by imposing a national insurance charge, which would not otherwise have been imposed, and the contractor cutting the cost of his contract, so that what is happening is that the revenue are taking a slice of the contractor's income?
Yes, that is indeed the
and then going back to the question about being able to complain, I was just thinking, Mr. Nye's point, if you were a small operator and you're up against some large organisation, you're not going to upset them and get into a row with them about this. But if it turned out subsequently that the determination had been wrong, how would you then get the liability for the national insurance, and how would that get returned to the small operate.
It's a very, very good point. We were talking to HMRC about this at our last members meeting, and they are saying that you can, anyone who is paid on payroll and feels that they've been overtaxed can reclaim that, but it is not clear and it's not an easy process to reclaim. So if I was to reclaim overpaid taxes, if I was found inside IR35, I might get my taxes back, but then the employer would presumably get the employer's national insurance back. But if that's come out of my rate, I've got no chance of getting that bit back at all.
It's very hard to unravel this, actually, and particularly given that you'd have to wait currently till the sort of end of the tax year to do this, and then you'd spark an investigation that would rumble on for a couple of years, and then you'd eventually decide, no, IR35 didn't apply at all. But as you say, probably most of the tax actually been paid as employers and which has been paid by someone else. You'll have to get that back at a county court or something. I mean, it's very, very difficult to imagine how it would happen.
It's okay. HMRC told our members it's not insurmountable, so...
But there's nothing in writing. There's no record in these situations that the client has basically said, well, I owe X in national insurance contributions for you, employers' national, and I'm taking that out of the money that I pay you. There's nothing that explicitly tracks that. So I fail to see how that money is to be reclaimed.
Absolutely. Now, I know that some members of the panel have got to go at 4:15, which leaves us with 4 minutes, but would it be fair to summarise your evidence that, given that the government's policy is about simplifying the tax system, this is perhaps a challenge?
Yeah.
Yes.
Thank you so much.
Thank you.
Thank you.